The federal law, we know the paradigm of content versus non-content, and essentially the legal process that we need to obtain in order to get the good stuff or the basic stuff. We know that, for instance, a subpoena can get a subscriber and account information, um, as well as various other non-content items or the outside of the envelope, so to speak. And that if we want the good stuff, the content, the email accounts, and the location data, we need to go to the search warrant paradigm. But we can do everything right, and yet occasionally we get a nastygram from the electronic service provider, your Googles, your Yahoos, your cell providers, any number of reasons. These objections may take any form. It may be a technical name. In other words, if you still address your warrants to Facebook, Facebook's going to say, I'm not Facebook anymore. I'm Meta Platforms. It could be that you sent the legal process on day one and they didn't review it until after it was due. Or it could be they could get our law within our states wrong. They also could delay production of a warrant return for an extended period of time. And for us, it's, well, I need this information to continue my investigation, or I may be on a deadline, a speedy trial deadline, or what have you. They also may charge exorbitant fees for the production of the data. We also see within certain companies, and this isn't really catching on yet, but it very may well, and we see this with Facebook Messenger, is they may use end-to-end encryption or may not be able to provide you data that you can read. So what happens when that happens? Well, with the technical objections with the wrong corporate name, people are entitled to be called the right name. If you started calling me John and yelling at me saying, John, why aren't you answering me? I'd go, John's not my name. They're entitled to be called by the right name. The other technical objection that we see is that the company may not be subject to the ECPA. They may not be an electronic communication service or a remote computing service within the ambit of the statute. So we need to look at that. But this is the one objection where they may have some credibility. And I remind you to pick your battles. If it's the wrong corporate name, ask to speak to the legal department. I know with some of these companies, it's like impossible to get in touch with somebody on the phone. But if you communicate with a portal saying, hey, I understand this, I really need the data. Can you just give me a pass this one time? Most people are reasonable. Or you can say, hey, I'm going to reissue the process. Can you have the data waiting so that way I don't have to wait a long amount of time? Um, if that fails, you're going to have to fix the legal process anyway. Now, if the company is not subject to the Electronic Communications Privacy Act, I would investigate the company and see whether or not it really is a remote computing service or an electronic communication service under the statute. Um, Sometimes they're not. I had a case where the email address belonged to a real estate company, and the gentleman was implicated in a huge fraud scandal. The company was very reasonable. It said, I'd love to provide the data, but legally I can't. But I can hold the data for you if you can find a way to domesticate your warrant here. We were unable to do so. But needless to say, they were correct. It wasn't subject to the ECPA. So this is the one objection that may have some merit, and I think we need to look into and do our best negotiating here. However, the rest of the objections are, I would say, I'm open to litigating, and I think when we litigate these issues, we show the electronic service provider that we're not going to allow them to push us around. That when we provide valid legal process under federal law and under our state's law, that we are entitled for that process to be honored. So one of the objections I know we all get from now and then is, listen, we got your process, but we didn't review it until after it was due. Well, my response to that is, I'm sorry, but that's not my problem. I want to speak to your legal department. The legal process was timely. You're the one who's not in compliance. And you know what? You either provide it, or I'm going to move to compel your compliance and seek a contempt citation. And if this is a repeated problem within your office, or if you're in a state where you have some coordination with each one of your offices, if it's a repeated problem, consider consolidating those to show the court this is a repeated problem, it's unacceptable, and we're not going to stand for it. If there is one objection that really, really aggravates me, it's when a company tells me, I'm sorry, we're concerned that your process is legally stale. They do not have a copy of our affidavit. They have a copy of our warrant. So I don't know where they're drawing this conclusion in many regards, but they are not entitled to draw that conclusion. They are not a judge that reviewed the process, and they can't sit extrajudicially overseeing our courts. It's wrong. And unless we stand up to it, we allow it. We can't allow this to happen. My simple response to this is, you're not honoring your warrant? Okay, that's fine. Let me know if you're not going to honor it by a certain date. If not, I will pursue the appropriate legal process to compel you to do so. More often than not, they comply. If they don't comply, the minute we file the motion, they will comply. If they still don't comply, I have no problem going in front of a court and litigating the matter. They often cite legal precedent that involves civil legal process, not criminal legal process. So what I want you to do before you go to that motion to compel is to consider if your legal instrument is accurate. Make sure that it isn't stale. Make sure that it isn't, that it is properly issued. And respond that you are considering legal action. Follow through with it and consider related legal actions for it. Um, if we don't stand up to this sort of behavior, we allow it to happen. And that's not acceptable. That's not why we wear the white hat and we do justice each and every day as prosecutors. The other thing that we get is a lot of the electronic service providers are located in California. And we occasionally get this with subpoenas where certain companies say, hey, I'm sorry, you need to domesticate here. We see that with Burner app more often than not. Now, one of the things, especially with subpoenas, is, okay, let's just say they're right and that a subpoena may not be good there. A D order under 2703D is a federal court order issued by a state court judge, so it's entitled to nationwide process. As long as we provide non-conclusory, specific, and articulable facts, what I know is a bar discussion. You and I sit down at a bar, I don't want to know your life story. I just want to know what you do for a living, in a non-conclusory fashion. That's entitled to nationwide process, and it should be honored by them. The other thing that we can respond as is essentially if they're a California corporation that provides electronic communication services or remote computing services, the California Penal Code says, listen, a warrant issued by another state should be honored as if it was issued in California. And we see the same with the California Corporation Code. This is another area where we not only have their state law supporting our claim, but we also have our own law and the federal law supporting our claim that, listen, you can't dodge it because you live in a different state. The federal law and possibly our own state laws support the claim that you need to honor your legal process. You make billions of dollars every year. You need to comply and have a proper legal department in order to do things. As a last-ditch effort, you may consider domesticating, but when you domesticate, you're then subject to their laws, and then you're in their playground, not yours. So domesticating a subpoena is essentially, and I love people say that, listen, this is, I don't know how to domesticate. All it does is reaching out to a friend in that state, in that county prosecutor's office, DA's office, state's attorney's office, and say, hey, you have a company in your jurisdiction. They're not honoring our subpoena. Can we talk? And whatever can I send over a copy of my legal process? You then adopt it and issue it as if you're located in your state and your county. So domesticating is essentially is saying this legal process, we want it to be with the fancy stamps and other things as if it was issued in California or Washington or what have you, wherever the company is located.
Thank you.
One of the reasons we have this issue is that the ECPA lacked a specific preemption clause. The legal history, however, seems to hint that it was intended to preempt, and there's mixed case law in the area of it. The other area where we also see an objection is they try to interpret our state law. Now, one of the areas that I saw this in the state of New Jersey was essentially for a while, call detail records, a lot of state prosecutors believe that you had to issue a warrant to get these call detail records, which was shocking for me in New York because I just issued a subpoena for them. State Supreme Court looks at it in 2016 and says, you know what, you can get them through a D order. So Facebook and Google says, well, you need a CIO or a communications information order or a D order to get subscriber information and transactional information now. Well, they were misinterpreting the ruling in Lunsford. So we had filed a motion to compel um, to clarify the court, to force Facebook and Google to comply with that those legal processes. And there were a lot of them, a lot of touching cases. And ultimately, the Supreme Court clarified its opinion, saying this is only limited to call detail records. Everything else remains the same. And then Facebook and Google began complying with the process. But it's a classic example of, if they may get our law wrong. They're a nationwide and in many ways a global company. So they may think they understand our law, but they're not licensed. They don't do the day-to-day. We do. And if they get it wrong, we need to say you're wrong, and we're going to bring your feet to the fire if you don't comply with legal requirements within our state and within the federal law. So in summary, what I want to impress upon each and every one of you is, I know it's easy to say, you know what, I'm just going to do whatever the provider wants me to do, but then guess what? They're going to continue to push you around. It's your job to uphold the law and to enforce the law, and that includes the ECPA, because ultimately we're issuing this legal process to further our work as prosecutors. Asked to speak to the legal department, consider that contempt act. And the other thing I want to remind you is keep statistics. We want to know how often legal process is denied, because ultimately every so often everybody goes before Congress and they say, well, we provide all this information without a warrant. And it's, well, you do, but you do because we're not required to get a warrant, or we're very cooperative with law enforcement. Really? Because you've objected to our process X amount of times, and it's frustrated our investigations. And there are any number of reasons why you keep statistics on any number of things, like not getting into phones, to show, well, listen, we're getting to a point where we may not be able to get any evidence from it because it's password protected and it's encrypted. The other area that I want to talk about briefly is charging for data. The federal law allows for electronic service providers to charge reasonable fees for producing records, but those fees must be reasonable and agreed upon. If there's no agreement as to the fees, the matter goes to the court where we issued the legal process. So they're not in their home court, they're in our home court. And there is an exception to the statute, and it relates to phone subscriber and call detail records. And phone subscriber and call detail records. We're not talking about cell site, just call detail records and subscriber. When the federal law was enacted in 1986, it was fairly routine and easy to obtain those records. So therefore, Congress said, hey, no charge for phone subscriber and call detail records. If you're asking for more than that, then yes, they are entitled to reasonable fees. We see that out with the case law as well. There's really two main cases in this area. One is Michigan Bell, and the other one skips my mind at the moment. But what I can say is that essentially Michigan Bell is saying, hey, toll records, they're excluded from reimbursement. What's interesting is back in 1986, you had to essentially shut down a server in order to get content records. I think when you look at what's reasonable, I would argue that it's very easy to obtain subscriber records, to get email content now than it was in 1986. And we see that out within the case law. Microsoft versus US was overruled by statute, particularly the Cloud Act, but they provide details about how easy it is to get their records. So use their words against them if you have to go to a cost hearing. And then the other thing that I would look at is does your state allow for a company to charge for production of records? If it does, then you may rely on that. But they can't essentially say, oh, we're going to go poor, and they make X amount of money a year on all of us in using their products, and try to charge us for really what is a matter of what I like to think is justice when we investigate a case. Don't be afraid to do a hearing on this. I would think it's very fun. On one case, Dropbox was holding information on a gentleman who was extorting boys. And I said, listen, you're allowing abuse to occur. We need these records because we want to arrest this guy. They complied almost immediately when they learned what was going on. We were not going to pay $5,000. Nobody should have to pay $5,000 to stop abuse from happening, to stop a homicide, a violent incident, a non-fatal shooting, any fraud case. I like my money, and I don't want anybody else to have my money unless I'm required to give it over. In that regard. So if they try to charge exorbitant fees, say, you know what, I'm not going to put up with that. I'm going to rely on the federal law in order to bring a reasonable fee if you're entitled to it. and I'm going to do my job because that's what we do each and every day. And that's the reason why I love this job. And I know many of you here do.
And I'll just talk briefly about, in the context of this particular topic of dealing with third-party providers, we did a reverse keyword search. I put the case because it ended up in a published decision in our state Supreme Court. We did a reverse keyword search to identify the perpetrators of a quintuple homicide, arson homicide. We were and the case is still ongoing, so I can only really talk about what's in the published opinion. But basically, we had reached out to Google. We had said, Google, we want to know who had searched for the address for this house. We had particularized grounds to believe that the people that committed this offense would have had to have conducted a search for this address, and we articulated that in the affidavit. And so we didn't have anything to go by, so we went to Google and we said, here you go, this is what we'd like. And Google first said, no, we're not giving that to you. And I was glad that they did, because because we didn't have any go-bys, we just said, we tried to be very limiting, but we didn't ask for the data in an anonymized fashion like you might in a geofence. So they said, if you do it that way, we'll be okay. And we had these conversations and they were very, helpful. And then we came back with another version. And again, it was anonymized this time, but it had the language that was still specific to more to the location data. And so we talked to them again, and that really gave me an opportunity to try and figure out what kind of data do they have in addition to just these searches themselves that we could tap into, keep it anonymized. So through those processes, we had several conversations and we were able to come up with the third warrant. So we withdrew the first two. And then the third one, they complied with, and we were able to identify our suspects. And, that once we did, it opened it up to a whole lot more evidence. So sometimes working with the third-party providers can be helpful, but I would say it's fairly limited in terms of those scenarios when you're dealing with maybe unique circumstances where you're trying to make sure that you're tapping into the data that you need, because we don't know all the time what kind of data they have, how they're able to retrieve it. So that was a unique experience. My experiences with Google since then have been more in the form of responding to the objection letters, where they take it upon themselves to determine, not having seen the affidavit at all, that the data we're requesting in a geofence is too voluminous, and so therefore the warrant must be overbroad. And after a few phone calls with them to try and understand where they were coming from, now I just respond with an email saying, no, that's not your position, among other things. And, you need to provide us with the data. And that's been, for the most part, much more successful, knock on wood.